All right, so welcome everyone. Thanks so much for joining us. My name is Noel Semple from the University of Windsor Faculty of Law, and this is our panel on closing the feedback loop, designing justice through data. Two terrific presentations, and then me. I'll just begin by introducing Hannah, who will be speaking first. Hannah is joining us today from beautiful Nova Scotia, where she works with the Dalhousie Legal Aid Service in Halifax, and specifically leads the eviction prevention program. And she has a background in academia. She holds a PhD in sociology from Dalhousie University, and continues to pursue academic work along with access to justice work on behalf of tenants and other people with legal needs in Nova Scotia. So please join me in welcoming Hannah.
Okay, thanks everyone. So good afternoon. Like Noel said, I'm a community legal worker at Dal Legal Aid in Halifax. So if you don't know much about Dal Legal Aid, I'm about to tell you. It's part of the Schulich School of Law at Dalhousie University. It's actually one of Canada's oldest clinical law programs, maybe the oldest, I'm not sure, having began in 1970. And this actually predates our provincial legal aid commission. We have a threefold mandate, so to provide legal aid services for people who would not otherwise be able to obtain legal advice or assistance. So the areas of law that Dal Legal Aid focuses on are family law, child protection, youth criminal justice, and administrative law, including residential tenancies and income security appeals. We have 7 staff lawyers, 4 legal assistants, an articling student, 3 community legal workers, which I am. We're not lawyers. We primarily work in areas of administrative law, supporting a public social justice clinic for people dealing with landlord-tenant disputes or income security appeals. So in 2025, the social justice clinic had drop-in appointments or phone appointments with about 700 people, the majority of whom were dealing with residential tenancies issues. And so when someone comes into our clinic, we can do a few things for them. We can just offer them legal information about options. We can consider them for representation with the clinic. Or we could also sort of give them summary advice. I say that's in conjunction with our lawyers. But yes, we see quite a few tenants come through our doors each year. And then we also provide an educational experience in the solution of legal problems for students enrolled in the Faculty of Law of Dalhousie. And so each semester we get about 10 to 15 students who are in their final year of law school to join us for placements in clinical law. And then we also conduct research, provide information, make recommendations, and engage in programs related to legal aid and law reform in the province of Nova Scotia. So we're quite active in bringing forward test cases, making law reform recommendations to committees and so on, especially in residential tenancies law. And there are really very few others in the province who are doing this as it relates to residential tenancies law. So in recent years, Dal Legal Aid's work has meant that we're really in the front line of tenancy issues in Nova Scotia. It wasn't always the focus of the social justice clinic, but since 2019, it has really dominated, and it often puts our capacity to test with just the volume of people that are coming in. So anecdotally, what we were seeing was this increase in the demand for legal information about tenancy issues. More and more people were coming in about tenancy issues. These included evictions, repair issues, like conditions and pests and so on, security deposit returns. But when we looked at the data about who was actually going to the provincial residential tenancies program, how many applications were being made, we found that the number of disputes actually going through the dispute process was not different than it had been before, or not meaningfully different, but at Dal Legal Aid, we had seen an explosion, it felt like. So we were seeing this mismatch between what we were anecdotally seeing with the number of tenants that we saw having problems and the number of tenants who were actually making it through those formal dispute resolution mechanisms. And so that kind of left us with some questions, like, is Dal Legal Aid in some sort of bubble? Are more tenants actually having issues? And how are they solving their tenancy issues when they do have issues? So I started at Dal Legal Aid last year to lead this research project on access to justice for tenants in Nova Scotia. And we began this research with the goal of improving the services we provide for tenants. We're guided by these 3 questions. What is the volume and nature of tenancy issues faced by renters in Nova Scotia? How and why not do tenants access justice for tenancy-related issues? And how do demographic and socioeconomic factors influence tenancy-related issues and access to justice in Nova Scotia? And I just wanted to also talk about what we kind of see as the 3 pillars or foundations of protections for tenants. So, I mean, one is rent control or vacancy controls, laws and regulations that control the rate of rental increase, allowing housing to remain affordable for most people. So many jurisdictions have some form of rent control, whether tied to the tenant or to the unit. In Nova Scotia, there has been a rent cap in place since 2020. Tenants are protected from excessive rent increases. Your landlord can't raise your rent more than 5% a year. And the rent cap legislation, that's a temporary legislation that's only in place until 2027. A fair dispute resolution process is another foundation of tenant protections. So under our Residential Tenancies Act, dispute resolution for landlord-tenant matters is handled by the Residential Tenancies Program. Both landlords and tenants can make claims through the Residential Tenancies Program. Hearings take place over the phone and are presided over by residential tenancies officers who are public servants. There's no law degree required for this position. It's just like a bachelor's. There's always an option for mediation. And the wait time for residential tenancies hearings in Nova Scotia is usually around 2 months or less. And all decisions can be appealed through a hearing de novo in the small claims court. And when we began this project, there was this issue with the lack of data when it came to residential tenancies program. There are still data issues. They have been trying to improve it and working on it. But the decisions are not public. There was no easy way to figure out things like how many people were evicted last year in Nova Scotia, or how many people have representation in a hearing versus how many people don't. There's just, that information was not even being collected. And then what I want to talk about a little bit today is security of tenure as a foundation for tenant protections. So it's important for tenants to be protected from no-fault evictions and trust that their tenancy can continue for as long as they like. So in Nova Scotia, we have this interesting system where some tenants have security of tenure and others don't, depending on their type of lease. And this creates a disparity in tenants' rights, and this in turn creates a disparity in the ability to access justice for other tenants' problems. So this was something we had suspected when we began this project, but again, there really was no data, and because the difference in security of tenure really depended on the lease type that individual tenants had with their landlords, this data did not exist outside of individual leases, which aren't collected anywhere. So we set out to collect and analyze some of our own data. So we did do some freedom of information requests for residential tenancies data, and also taking a sample of residential tenancies cases that were in the small claims court, which I can also talk about if you're interested. I was at a session yesterday afternoon where a gentleman was talking about his analysis of court cases, which he said this is a population level. I didn't take a sample. I looked at all of them. I think it was self-represented litigants. This We did not look at all of them. It would have been too many, but we did take a sample of residential tenancies cases in the small claims court. But our biggest undertaking was collecting data directly from tenants themselves. So we did launch a province-wide tenant survey to try to answer our research questions about the issues tenants in the province were dealing with. It was open to anyone living in Nova Scotia who was 19 or over and who had rented in Nova Scotia within the past year. It was a 60-question survey with questions ranging from building and landlord characteristics to demographics to disputes. And in the end, we received 1,278 responses from throughout the province. And we heard, this map shows we heard from people from across the province. And I did want to just share a quick slide with some comparable previous efforts to collect data on tenancy in Nova Scotia. So prior to our research, there had been really no study specifically looking at tenants' legal issues in Nova Scotia. And this is an issue because the Residential Tenancies Act, it's frequently updated. Policies and regulations are frequently changed, but tenants are rarely sort of consulted in these legislative changes. And I just want to talk a little bit about some of the results from our survey. So we wanted to know about the lease terms of tenants. And so we found that 26.7% of our survey respondents who answered the question about their lease, the type of their lease, were on a fixed term lease, which is a lease that doesn't automatically renew at the end of the term. So the most common type of lease was a year-to-year lease, which does automatically renew each year in the anniversary date. But when a tenant is on a fixed-term lease, there is a fixed start and end date. If the tenant wants to stay beyond the end date, they have to sign a new lease with their landlord. So both the tenant and the landlord must agree that the tenant can stay. And there are no notice requirements for this because it's sort of agreed to at the beginning of the lease that it ends on that certain date. So, and there's also no legislation in Nova Scotia that limits the length of a fixed term lease. So in our legal clinic, we see 1 month fixed term leases, 3 months, 6 months, but probably the most common, it would be one year fixed term that each year that tenant and the landlord would have to re-sign if they wanted to stay, if the tenant wanted to stay. And the interesting thing, we wanted to look at this over time. And so we know that 26.7% of the survey respondents reported being on fixed-term leases, but when we compared this with the length of their tenure, so how long it had been since they had moved into the unit, it becomes apparent that fixed-term leases are becoming more prevalent over time. So in this graph, the pink line is fixed-term leases, and the darker line is all other types of leases. And you can kind of compare this also with legislative changes. So I don't know how easy it is to see those years, but in 2012 is when the Residential Tenancies Act changed to give people on periodic leases automatic security of tenure. And then 2020 is when the province introduced the Interim Rent Cap Act. And so the surprising thing for us when we had done this research was that of those who moved into their units in 2025, more were on fixed-term leases than on periodic leases. And so we had some more questions with the impact of this. So one question was, are fixed-term leases being used for certain types of apartments, like for lower-income people? The data doesn't necessarily show this, though. The rent cost for tenants who were on a fixed-term lease was not significantly different than the rent cost for all tenants. Proponents of fixed-term leases also claim that certain segments of the renter population want fixed-term leases, such as students or newcomers. But at least in our sample, it seemed like fixed-term leases were being used widely across the province and across demographics. We also found that all types of landlord were using fixed-term leases, so not just REITs or property management companies or private landlords, but also public housing and nonprofit housing agencies. So what our survey results show us is that this type of lease term is widely used across Nova Scotia. It's becoming more and more dominant. And this has coincided with low vacancy rates for rental units in the province. So, if the choice for a tenant is a fixed term lease or you don't get the apartment, they're probably going to choose the option that gives them housing, even if that housing is not as secure as it could be. And, okay, I got to talk about how this interacts with access to justice. So, here is a table that just kind of shows the amount of applications filed by both tenants and landlords for the residential tenancies program in each year. So a Form J is just an application for a hearing. A Form K is an rental arrears eviction. So you can see that it's a pretty high number, but it's stayed relatively stable between 2019 to now, even as the number of renters in the province continues to rise. So it's possible the proportion of tenants who have problems with their landlord has declined, but we don't have any evidence why that would be the case. It's also possible that disputes are being handled outside of the program, but again, we don't have evidence why that would be the case either. So we did ask on our survey questions to understand why tenants may not be going through these formal channels to solve residential tenancies issues. So first we asked whether they had a problem with their landlord, unit, or building within the past year. And then we asked what kind of action they had taken to solve the problem. And we gave a list of possible actions. For example, not taking action, making an informal demand of the landlord, making an application to the residential tenancies program, and so on. And about half of respondents reported having a problem within the past year, and of those, 42% took no action. And about 6% made applications to the residential tenancies program, which is the formal way to resolve disputes. So they could also choose multiple responses to the questions of barriers they face to take more actions. So hopelessness was the top barrier reported, followed by damaging the relationship with the landlord. Other barriers included stress, not knowing what actions to take, being uncertain of their rights, being too afraid to take action, thinking it would take too much time, or cost too much. And so we are kind of suggesting that these barriers are a direct result of the growing prevalence of fixed-term leases in Nova Scotia. And some of these barriers can be overcome. So we have done Dal Legal Aid and Nova Scotia Legal Aid as well. We've put a lot of work into our public legal education around tenants' rights. That's not a topic of the presentation. I'm happy to talk more about if anyone has questions about that. But also the program to actually make an application is pretty low barrier. You can do it online and submit evidence online. You can also do it in Access Nova Scotia location. It does not cost very much. You get those fees waived if you're low income. Hearings are held over the phone. It's common to go through the process without legal representation. That's not always a barrier for people. And the timeline from application to hearing is usually within a couple months. So there are always ways to improve the system, but the program itself is pretty easy for a layperson to navigate. But tenants need to actually feel like they can safely access dispute resolution without losing their housing. So that's what's missing in Nova Scotia. So our survey indicates that tenants are aware of entering into disputes with the landlord, and there's no rules, there are rules about retaliation, but not when you're on a fixed term lease, because it just ends when it ends. So there's a few news stories I have on these slides. Hopefully I can share them at some point, but there's stories about people basically being successful in some cases in their claims in residential tenancies, but that success later ends to them, the landlord choosing not to renew their lease, right? So access to justice, I guess I just will follow up by saying that, lack of security of tenure and this legislative problem is eroding access to justice. So where it is being improved in some ways, the usefulness of the formal landlord-tenant dispute mechanism is diluted by the lack of legislative protection for tenants, and access to justice can only go as far as that legislation allows in Nova Scotia. And this is all in a report, so I do want to just give the plug for our Human Rights and Housing Crisis report that goes into a lot more detail about our research about access to justice for tenants as well. So thanks.
Thanks very much, Hannah. Appreciate it. So up now we have Glenn Ng, who is with the Social Security Tribunal Secretariat here in Ottawa, which of course is a federal tribunal. And he is an expert in using mixed methods research to evaluate tribunal performance with a special focus on the access to justice dimension and self-represented and vulnerable users. That's work which he's done in various tribunals in the federal system. And he's a graduate of York University, like me, and lives here in Ottawa with 3 kids and 2 cats. So welcome, Glenn.
All legal dependents.
All right.
Better turn that on. Okay, good afternoon, everyone. So, as Noel said, I'm with the Secretary to the Social Security Tribunal, which is a branch of the Administrative Tribunal Support Service of Canada. It's a small federal government department that provides centralized support services to a cluster of federal admin tribunals. And unlike most speakers at this conference, I'm not a lawyer or an academic. I'm a program evaluator by training. And most federal government departments have a team of program evaluators whose job is to assess the performance of public programs and services and to recommend improvements based on the empirical evidence. And that perspective shapes everything I'm going to share with you today. So this slide sort of maps out what it is I will share with you. And first, I'll give you a brief overview of our organization, its operating environment, and importantly, a profile of the people, the parties that we serve. I'll then illustrate how data supports people-centered justice, and I'll end with a set of practical takeaways acquired through a lot of trial and error. Throughout, my focus will be not on the policy choices that were made to improve people-centered justice, but on the data story behind them. What data we collected, the methodologies that we designed to measure and evaluate performance, and how different lines of evidence came together to confirm whether we were achieving our intended outcomes. I'm going to get quite geeky about my job, so I apologize in advance. So our tribunal hears appeals by individuals against government decisions on employment insurance, Canada Pension Plan, Old Age Security, Canada Disability Benefit. Those social benefits, by their nature, define the population groups that make up our user base. Many come from vulnerable communities, people with disabilities, older Canadians, people in financial distress. Importantly, up to 85% of them are self-represented. So that means that our tribunal is working with SRLs who are often overwhelmed and distressed by the legal system. Those intersecting realities shape everything. How people understand us, and the choices that we make, the data choices that we make to better understand them and the barriers they face. One of the biggest advantages of working in an admin tribunal is that we sit on a goldmine of primary data. Every case, every document, every hearing, every click on the website generates signals about how the system is functioning. And what's important is that these various data sources give us multiple vantage points about how well the system is working. For example, SRLs tell us what they think and feel when they interact with the system. And they do this through complaints and inquiries, user surveys, and focus groups. Website analytics tell us what users try to find or fail to find. Case files tell us how SRLs pursue and progress with their case, and so on. All of this data is already built into tribunal operations. The challenge is to find and extract that data. And this slide describes the methods we used to do that. On the left, you see some of the quantitative methods that we use to look for patterns and trends and correlations. And we do this by analyzing system analytics, quantitative surveys, demographic statistics. But numbers alone, of course, don't tell the story. That's why we also use qualitative methods, focus groups, document reviews, linguistic analysis, one-on-one interviews. These methods give context to the numbers. What's key is that we try not to use one method alone. Whenever possible, we'll apply multiple methods and triangulate. That is, check to see whether the same finding is showing up across multiple and independent lines of evidence. So this sets us up for the 3 case studies I'm going to describe next. In each one, you'll see how we use different combinations of methods to diagnose issues and evaluate whether our interventions were achieving their outcomes, their intended outcomes. So this first case study focuses on the readability of tribunal materials. Before interventions were made to improve readability, we were experiencing a situation where users and stakeholder groups were telling us that our tribunal documents were incredibly difficult to read and understand. Form letters and fillable forms were confusing, written guides and adjudicator decisions were just laden with legal terminology. A post-secondary education was needed just to get through these materials, and we were supposed to be a quick and informal tribunal. Considering who made up our user base, this placed an unfair cognitive burden on our readers. So in response, the tribunal introduced a suite of interventions to change not just individual outcomes, but the organization's writing culture. These included a standardized style guide, a glossary, template letters and forms, and new templates for adjudicators' decisions, all aimed at cultivating a simplified writing culture at a grade 9 level. The next slide looks at how we evaluated those reforms. So first, we used automated text analysis tools, the kind you find on your desktop software or on the internet. These gave us quick numerical readability scores based on countable data points like number of syllables, sentence length. It's a quick way of setting a numerical baseline and doing before and after comparisons. But of course, algorithms can't tell the whole story. So what we did is we brought in independent language experts, and we gave them the job of reviewing a sample of our written materials and asked them to review things like tone, clarity, structure, logical flow, negative space. And the third line of evidence, and the most validating for me, was feedback from SRLs themselves. We conducted surveys and focus groups. We gave them decisions to read or template letters to read and asked them to tell us what they understood and what they found confusing. And that added rich qualitative data about actual readability from real readers. And finally, we hired specialists in diversity, and we asked them to review our documents through a lens of inclusivity and accessibility, particularly for disability-inclusive language and gender-inclusive language. So the point of this slide isn't that we didn't rely on one single metric. We evaluated readability from multiple angles: quantitative, qualitative, expert, user-centered, inclusive. And that combination gave us a robust picture of results. And in terms of actual outcomes, users told us our materials were much easier to read, with some areas still needing improvement. Third-party experts confirmed that structures were clear, and point-first writing was taking hold. Inclusive language was widely adopted, with gaps persisting, particularly in the French language. Taken together, though, the triangulated evidence confirmed that our plain language work was paying off, and SRLs were finding it easier to read our materials in a measurable way. The second case study looks at UX, or user experience. Previously, parties and stakeholders were telling us they were deeply dissatisfied with UX. Tribunal processes were complex, difficult to follow, not transparent. Wait times were long, and accessibility wasn't necessarily front and center. From a user perspective, this created uncertainty and frustrations, even when outcomes were ultimately fair. In response, the tribunal implemented a suite of people-centered interventions to simplify the user experience and reduce those frustrations. Things like removing procedural steps, introducing clearer service standards, providing information in multiple and accessible formats, increasing transparency, strengthening accessibility and accommodation supports, and active adjudication. Taken together, these interventions aim to make the process more user-friendly while maintaining fairness and independence. And this slide shows how we evaluated the effectiveness of those interventions. Again, our approach was not to rely on one single tool for one line of evidence. We first drew heavily on direct user feedback. Through surveys and focus groups and usability testing, users told us how they were experiencing our processes, what was working and what they were still struggling with. Second, we paired that data we paired that data with data from by mining our case management system. And this let us track patterns behind the scenes, like timelines, touch points, and bottlenecks. And this grounded the qualitative stories in operational evidence. And third, we applied a GBA plus lens to find ongoing barriers. GBA plus is gender-based analysis. It's an analytical approach we use in government departments to assess how programs and services are impacting different population groups like gender, income, age. And finally, we benchmarked against best practices in the administrative justice world. A great tool that we relied on is the Department of Justice's Access to Justice Index. So all of that evidence we collected produced this list of numerical findings. What's key is not any single number, but the overall pattern. First, users gave us much higher satisfaction ratings. They told us they were satisfied with regard to fairness, timeliness, and feeling respected. Second, operational data showed that hearings and decisions were increasingly being completed within published service standards, lending predictability to the process. And third, with the demographic data that we collected, we had a much clearer understanding of who our user base was and their specific needs. And by disaggregating those different user groups, we found that UX held strong across the board, with ongoing pain points faced by certain party types. One example is older SRLs who lack digital access and therefore lack the ability to participate in our digital services. The third case study focuses on a single intervention. That's the Navigator service. Before this service was launched in 2019, most SRLs were experiencing the system, navigating it on their own. Many struggled with readiness before their hearing, missing key steps, misunderstanding expectations, or feeling unprepared for their hearing. The Navigator service was designed to address this gap. Once an SRL comes into our system, we assign them a navigator to work with them one-on-one. And their job is to provide procedural guidance, information, and reminders to help them stay on track. The next slide looks at how we evaluated this service and to the extent to which it achieved its intended outcomes. There. Again, we relied heavily on direct user feedback from SRLs through our regular post-hearing survey. But we also arranged for third-party experts to meet with a sample of our users to interview them one-on-one and draw independent conclusions about the effectiveness of the service. We then paired that feedback with feedback from internal actors, the navigators and adjudicators, through internal surveys and focus groups. We next applied a GBA plus lens to understand if the service was meeting the needs of all demographic groups. And another method was to compare navigated SRLs against a control group. Control groups are a powerful research tool that allowed us to isolate and measure cause and effect relationships and compare impacts against a comparable group of SRLs who didn't have a navigator. So what did the data say? First, navigated SRLs achieved their pre-hearing milestones much quicker. They reported readiness for the hearing sooner. When they went to their hearing, they were more prepared and more engaged with the adjudicator. And we know this because the adjudicators were reporting clearer and more focused hearings. And also data from the case management system showed fewer postponements and delays. Finally, independent experts from academia and from the private sector pointed to higher access to justice outcomes in the form of better engagement and satisfaction from users who come from traditionally marginalized communities. So this brings me to my final slide, where I'll conclude with a few practical takeaways for like organizations. Start with people, not procedures. Data is most useful when it's grounded in lived experiences, especially from self-represented and vulnerable users. This means measuring for barriers, specifically faced by your user base, whether it's financial, technological, educational, and measure what matters most to those users. Many of the things that matter in access to justice don't show up cleanly in traditional performance metrics. Measures like confidence, readiness, and feeling heard are best obtained through perception-based feedback from users and staff. and then use evidence end to end. Across all 3 case studies, data wasn't just used to measure programs after the fact. We used it to diagnose problems early, design interventions, test them, and continually improve. And finally, build data capacity. This is probably the toughest puzzle, and I think that's why we're here at this conference. As a civil servant, I'm biased in favor of hiring more specialized staff, but in an era of belt-tightening, there are cheaper alternatives. It doesn't cost an organization any money to ensure that data and evidence are treated as leadership priorities, or to commit to being accountable, or to create feedback loops that lead to action. Another strategy is to leverage partnerships with outside expertise. These could be collaborations with other tribunals that form a cluster. It could be collaborations with community organizations and experts in academia or in the private sector that share your space and in turn can share their knowledge and expertise with data. Finally, all of what I do is fairly scalable and modular, meaning any organization can do what we do by starting small, then building outward. I think I'm out of time. No, I'm okay. That's it.
All right.
Alrighty.
Great.
Thank you.
Thanks so much, Glenn. I really appreciate it. Great. Yeah, and we're... Bonjour, je m'appelle Noel Semple. Je suis professeur associé à l'Université de Windsor, faculté de droit. And I'm delighted to be here today. And let's see if my slides are on deck. Still coming up. Oh, okay, here we go. So the weather's nice, and university term is over, and elementary school is almost over too. So that means road trip season is upon us. And road trips are great when you get to some place that's exciting and fun. But at least for me and my sister as kids, the question on road trips, sitting in the back of the car, was always, when will we get there? Kids today can't relate because they have smartphones. They know exactly when you're going to get there and know all the places you might be asked to stop along the way. But back in the day, you were sort of trapped in the back of a car in this state of mystery about when is this interminable voyage going to end. And people involved in civil litigation have this question too. Right? This is the same sense that people get, at least in Ontario, and I think to a large extent across the country as well, about civil litigation. When is this process going to get to its end? So I'll just zip forward a bit here because to show you this slide from the World Justice Project. Sorry, this is all theory, and Doug Ferguson said yesterday to cut all the theory out and just get to the solutions. So I will cut those slides out. So the World Justice Project does these evidence-based evaluations of justice systems across the world. And when they evaluated Canada's system, our overall score was 79%. But then they break it down into all these different subcomponents. So you can't see it, but factor 7 is civil justice. And then they break civil justice down even further into another 7 subcomponents. And you can't see it, but the bottom there is the extent to which civil justice is free from unreasonable delay. And that's 0.42, 42%. So this metric they use, they evaluate Canada's justice system on 43 different criteria, and this is the lowest out of all 43. The performance of the Canadian justice system in delivering civil justice free from unreasonable delay. So my project started as an effort to quantify and better understand timeliness in the context of civil justice in Ontario. So when I say civil justice, I'm talking, of course, about civil disputes before the Superior Court of Justice. So motor vehicle is the biggest chunk of that, commercial contract disputes, estates, employment. But I'm also thinking about civil justice more broadly to include the sort of work that the Social Security Tribunal does, where fundamentally civil disputes are handled in a tribunal or another function. So that's just to define my terms. But so timeliness in civil justice, what do we know? And how long is it going to take? When are we going to get there? The Chief Justice of Ontario said in a famous speech that it takes an average of 4 to 5 years to get from statement of claim to trial in a civil matter in Ontario. No details have ever been provided by the court about that. It seems like that might be basically anecdotal. And we really just don't know much. We are very, very far from the state of affairs that Glenn and his colleagues have created, where there's a comprehensive, empirical, quantitative picture of what is going on. So I am trying to fill that in a little bit in a very, very tentative, sort of amateur way, with a few different empirical inquiries. So the first thing we're doing is we're getting access to the last 400 or 500 trial records for civil trials that were held in Ontario. There's only about 400 or 500 civil trials per year in Ontario, to try to figure out how did those matter get there, how long did it actually take from statement of claim, and more importantly, where did all the time go among all the different phases and steps of civil procedure to get there. Now that's time to trial or time to disposition, which is a standard measurement, but it's not directly relevant to most of the people who are trapped in the back of the car trying to figure out when they're going to get there, because only 1 or 2% of matters end up at trial. A few more are adjudicated without trial, and some people here may have read Susie Kyoto's paper or her talk yesterday about summary judgment, which is supposed to be a quicker alternative to adjudication. That's a small and decreasing percentage as well. Over 95% settle, right? So if we're asking when are we going to get there, the real question is when are we going to get to a settlement? And will that settlement be just? Because settlements vary greatly in terms of the extent to which they actually uphold people's legal rights and give them what the law has promised them, as opposed to just constituting, giving up or abandoning the matter because you can't wait any longer or pay any longer. So to explore these questions, I felt like I needed a kind of a theoretical model, a model to understand civil litigation and the timeliness question and how and when and why these matters end, either through adjudication or settlement. So I call it the 407 model. Civil litigation is a road, right? That's the basic sort of conceptual starting point. And it's a toll road, like Highway 407. I don't know if anyone's taking a road trip on Highway 407 this summer, but bring an extra credit card if you do, because it's not cheap, right? Nor is civil litigation cheap. That's the number 1 and 2 things that people know and complain about are the fact that it takes forever and it costs oceans of money to be involved in civil litigation in Ontario. So it's a toll road, and we in the back of the car are asking, when are we going to get there? When's it going to end? And the only certain answer is that it will end for sure at the Supreme Court of Canada, right? Just down the road is where is the guaranteed ending place. And if you ask your lawyer, they'll have to tell you, if they're being honest, that depending on how litigious the people are, how much money they have, your case might not end until a decade has passed and you've spent $200,000 and the Supreme Court of Canada has decided. Now, of course, the significant thing is that we have waypoints along this road, right? So in civil litigation, broadly understood, we have these steps. We have the pleading stage, we have discovery, documentary and or oral discovery, we have mediation, which is almost a universal feature of civil litigation in Canada. We have motions practice, which goes with case conferences. We have pretrials, and then of course we have trial. And if we could see a little bit further down the road, we'd see appeal and enforcement and all those stages that go along. So these are kind of like kilometer markings by the road, in the sense that to get to the end of your destination, you have to go through these steps. And the more of these steps there are, the longer it may take. But the other key thing about these things is that they're also off-ramps. They are also opportunities for litigation to end. So part of my research has been long-form qualitative interviews with civil litigators across the province of Ontario. And a really key finding is that each of these phases is an opportunity for settlement. Both because settlement may happen directly in the context of it, so mediation, obviously, the goal is settlement. Discovery is also, personal injury people in particular told me, is a really key driver of settlement. So people settle during these phases, but even more frequently, they settle in anticipation of this phase, right? Because each of these things is a significant source of expense and often psychological costs for people as well. So settlement discussions are prompted by the imminent arrival of the next phase. And of course, the justice of the settlement, right? The extent to which it's a good settlement that accords with what the law demands is also informed by parties' anticipation of what's going to happen at these phases, and that changes the offers they make and so on. So that was kind of the interviews part, but of course I'm also trying to get some quantitative understanding of how long things actually take. So I've got a terrific research assistant, Olivia Mirasola, unfortunately couldn't be here, but she has been extracting data about next available date quotes. So basically, if you're trying to schedule a motion or a case conference or a judicial pretrial with a civil court in Ontario, many of them are on this website called Calendly, which is a scheduling website where you log in and you say, okay, I want to have a 90-minute motion at Brampton Civil Court. When can I do that? And it'll show you calendars. And it'll show you the next available date, right? So when you scroll through to August of 2027 or whatever it is. So we are extracting the next available date data from all these Calendly mini sites to try to get a picture of what the systemic delay is, how long in the future these dates are across Ontario. So the biggest finding is there's enormous variation. So for certain motions in certain courts, I think the highest one we found was 247 days until the next available date. Whereas there's another court where you can get a motion date tomorrow. Literally there's a 1 day gap to the next available date. Enormous regional variation, not only in how far in the future that date will be, but also in how the process even unfolds. So, there's something called assessment court, which exists in Milton. There is nothing comparable in Sudbury. The motions go by different names, and the rules for booking them differ as well. There's practice variations, which each court, and indeed in some cases each local judge has the authority to issue to actually change civil procedure for what happens just in that court. All right, so when kids in the back of the car on a road trip say, when are we going to get there? What they really mean is, can't we get there faster? And that, of course, is the other question that people are perhaps even more interested in about civil justice in this province. And we live in a data desert. This is a theme that's been hit again and again over the last couple of days. We know very little. The court tells us very little. And this was particularly obvious with our current effort to reform the rules of civil procedure in Ontario, the Civil Rules Review, where the working group wrote in their major report that they've been candid with stakeholders that this has not been a data-driven process. So, this is not something they're hiding. They just don't know any of the things that Glenn can tell you about the Social Security Tribunal, and they're kind of trying to rewrite the rules of civil procedure in that data desert type environment. But I did find this striking because if you go into a hospital and they say, "Look, we want to give you this new drug that we're giving to everyone now instead of the old drug," and you said, "Well, why are you giving me this new drug?" And they said, "Well, it's not a data-driven process. We just heard from a hospital in Singapore that this is better, so you're all going to take it now." Then we'd have some issues, but that's kind of where we are in the civil justice system. Okay, so what are our possible solutions? Well, adjudication is crucial, which is kind of a paradoxical claim, because I've just told you that 95 or 98% of matters settle. But whether settlement happens, how early settlement happens, and how substantively just the settlement is, seems to hinge on the prospect of adjudication. Not even real adjudication necessarily. Real adjudication is great, but just knowing that you can get to court, and if the other side is being intransigent, either about the substantive terms of a settlement, or they're being intransigent on a procedural matter, like they're not releasing documents that they should, the prospect of adjudication is what makes that move forward and what makes the other side give you what you or your client are entitled to in justice. So how can we possibly get more adjudication? Well, every lawyer who practices civilly in Ontario has been saying, we need more judges, we need more judges. And the Civil Rules Review people said, we're not going to talk about having more judges because that's in Minister Fraser's camp, and there's no prospect of new resources being released, so it's kind of an impasse. I think there is a way out of that impasse if we think a little bit more out of the box about how we can get just adjudication, bearing in mind the availability of just prompt adjudication drives just prompt settlement. So how can we get it? Well, I think the key is stop thinking about getting more judges and think about how to get more adjudication, perhaps without judges. Judges do not have a monopoly on adjudication. This is an obvious point to people in the tribunal world, right? Where non-judges have been providing, prompt, authoritative, just adjudication for 150 years in Canada. So that's part of it, the whole question of tribunalization. I think tribunalization is an old idea, but the notion of taking a subset of civil disputes and assigning them to a carefully designed, specialized tribunal still has a lot of room to run. I think there's also a lot of solutions on the demand side. So in my view, everything we do in civil justice that consumes court time should be scrutinized in terms of whether the justice bang that it delivers merits the investment of judicial resources that goes into it. So example number one here would be civil jury trials, right? Civil jury trials consume a lot more judicial time, and they open the door to a lot more procedural motions and appeals and things than do trials by judge alone. There's no constitutional right to a civil jury trial. Why are we still doing them? Not because anyone sort of rationally analyzed the bang for the buck, but rather simply because we've always done it and the courts say, it's our inherent jurisdiction, whatever. So demand side rationalization of the things we do and the things we allow to consume judicial resources is part of the answer here. Coming back to the supply side, we've talked about this idea of tribunalization. I think the second big idea is arbitration. So again, not a new idea. Arbitration is privatized judging, and it's a niche practice which is used mostly in high-value commercial cases. But there's also a form of arbitration for the masses, arbitration which generates access to justice for people who are not wealthy corporations. And the key idea here is that when a corporation or a certain group of corporations provides a business service, operates in a field of business that consistently creates disputes, the corporations should fund a just, timely arbitration scheme to resolve those disputes. And the role of government and courts is not to resolve disputes one by one, but rather to ensure that the system which is designed and paid for by the corporate players is in fact just and does not favor their interests. So resolution of air travel disputes, right? Your plane is canceled or delayed in the UK and Europe is sort of a leading example of this. And Canada may be moving in that direction as well. Big questions here about the privatization of justice. Trevor Farrow has a book about this, so I don't claim it's easy. But if you look at motor vehicle disputes, which are sort of about 40 to 50% of our civil caseload in Ontario, I think they have characteristics which are in some ways similar to this. Providing motor vehicle insurance, making money off motor vehicle insurance contracts seems to inherently lead to a lot of disputes about how badly injured the person is or what they need. So would a purpose-built, closely overseen and monitored but private arbitration scheme generate better, quicker access to justice for everyone involved? Number three is AI-assisted adjudication. So judgment is inherently human and must remain a human activity. But I think it's possible that humans, using carefully designed and regulated artificial intelligence, can become more efficient and even more substantively just in the judgments they render, specifically with civil matters. So the basic model here in a nutshell is that AI can be a fourth party, right? It's not a decision maker, but it assists the third party, who is the human, in reaching justice and creating reasons for what they're doing. So more concretely, this could be the AI is fed with a carefully defined set of inputs. So in a civil dispute, like what are our legally legitimate inputs? Well, we've got the statute, we've got the case law on that specific civil question. We've got the evidence from the parties, and we've got the submissions and the arguments for the parties. So if an AI is confined to those 4 legally permissible sources, and then digests them and spits out 3 or 5 different decisions that would be within the bounds of the law, the human decision maker chooses between them, and then the AI, in concert with the human decision maker, creates reasons. This, I think, is not unthinkable. And we are so far down the road of timeliness impeding accessibility that it might be time to make some compromises in terms of our expectation that everything will be a bespoke, 100% human-driven process. I'll just end by mentioning Ontario versus Doe. So this is a case from March where the government of Ontario sought an injunction to ban a protest on University Avenue. And they brought the injunction 24 hours before the protest was supposed to happen. And within those 24 hours, the parties drafted factums, they submitted them, evidence was heard before the judge, there was argument, and a decision was made 55 minutes before the protest was about to begin, denying the government's injunction request. And then reasons for decision came out 6 hours later. Right? So this is a 30-hour civil lawsuit. Obviously highly unusual in a lot of ways, but I do think that it gives us the question of if justice can be done with hitting all the important beats of civil procedure within 30 hours, do we have to accept 5 or 6 years? I think the answer is no, but I think getting there is going to require a little bit broader approach and thinking a little bit beyond the boundaries that the Civil Rules Review has given us, and that's basically my point of view on that. So thank you very much. And I think we have, we've got, 2:11, we've got until, when? When do we have until? 2:30?
30, yeah.
Oh, okay, yeah. All right, great. So we've got time for questions. And I'd like to open the floor for that. Or comments on the floor, or anything that maybe resonates with something you're working on?
Hi.
Hello.
I'm Kimberly from the BC First Nations Justice Council. And I just had a question, maybe for all of you, kind of contemplating what you're just talking about. It seems to me tribunals would be a good opportunity for lay users to interact with an AI type experience where the evidence is fed in, the statute, etc., the outcomes, and they can actually see what they would likely encounter as an outcome. I'm just wondering, is that contemplated? Have you seen other tribunals doing something similar?
Yeah, well, at the Social Security Tribunal, we're about to release a new policy and a practice direction on the use of AI. In fact, I think that's coming out either this month or next month. But one of the statements in those upcoming documents will be that, no, the tribunal will not be using AI for adjudicating. It might be used for administrative matters like translation, proofreading, plain language, those sorts of activities. But for those substantive functions of actually making a decision, we're not there yet. The technology isn't there yet, we think. The trust isn't there yet. We've had experts come to our tribunal to sort of describe what the state of AI is now in the justice world. And the consensus is right now, there's a lot of hallucinations going on, a lot of documented hallucinations, especially with regard to citations, for example. So right now, you could say it's touch and go. It might happen down the road, but it's just not there yet.
There was a demonstration of Beagle, which is being used in BC. I guess not on the adjudication side. I guess maybe it seems like AI is more advanced in Canada in terms of its deployment in the justice sector for advice giving now, and we haven't really seen anything on the adjudication side that I know of. Doug.
Hi, everyone. Doug Ferguson from London. When I was on the OBA board during COVID, I asked the OBA to find out how long does it take in each county in Ontario from the time you list a civil case for trial, how long does it take to get a trial date? And the response I heard we got back was they don't track it. So which I found incredible, that they don't track that. Do you guys have any recommendations on what data should be tracked in the civil system? Like you went online, as I understand it, Noel, and found the next available date, but that's not trial as such, you know? Do you guys have any thoughts on that?
I mean, I think this is a field in which tribunals have blazed the way. You know, the SST, the Civil Resolution Tribunal in BC, certain others. I think there's a sense in which tribunals are kind of like the cutting edge laboratory for civil justice, because I mean, you guys can do things, and you have like civil servants, and you're not I don't want to use the word hidebound about courts, but I mean, what happens in courts is very much driven by notions of judicial independence and tradition and due process and so on. So I think, you know, across the tribunals of Canada, you could piece together all the best practices for what needs to be tracked and reported.
Yeah, I could also speak, okay, what we saw with the residential tenancies specifically in Nova Scotia, this was very funny when we began our research because we had questions specifically about the residential tenancies program. How long does it take? Who's represented or who's not? Are people successful in their applications even? And we asked them and they didn't tell us, and we thought, oh no, is this the government not telling us information? But it wasn't that, it was they didn't collect that information themselves. When you made an application to the residential tenancies program, you'd make it online. On their end, they'd see your online application, print it off, and re-enter it into their other system, which only one IT person knew how to extract any data from. And eventually they have updated their system now, so it's much more streamlined, but it was because it wasn't a priority at the time, like for a long time, for government to update their tech. And that was really, so we learned something about, like, I think it was a funding and like a priorities of government of literally, like, they did not have the technology to actually collect that data, but now they do.
Hello, my name is Randall Harris. I'm with the Department of Justice. And thank you for your presentation. A lot of what you said resonated with what I do. And I'm with a shop that does a lot. It's a judicial affairs section. One of the tasks we have to do is to receive business cases from courts asking for more resources. You just mentioned the Minister of Justice decides on adding Superior Court judges in concert with the provinces, of course, but it's funded by the federal government. So, you know, you're looking at a whole system, and there, you know, data desert. Sometimes you get some data, sometimes you don't get much. But how do you assess whether you need a judge? You know, is that the key input in that? Especially when you have one order of government, federal government, that's funding just the judges, and the other, the rest of the court, which is the bulk of the resources, is funded by another order of government. And so you get business cases where judges are saying, we have no research support, so we're all overworked, therefore we need more judges. You say, well, no, you need more research assistants, you need more systems, you have to move away from a paper-based. Anyways, I'm not going to bore you with some of the challenges that comes with that system, but more broadly, I guess what I wanted to raise was Administrative Tribunal Support Service of Canada. It's part of the executive branch. There's, of course, independence, but you don't have that mixed governance as you do in courts, where you have the Chief Justice has authority, judicial independence protects a certain sphere, but then you have the Court Services branch that is also involved with running the courts, and so you have a divided accountability right away. You have two boss system, I guess, in a sense, and sometimes they're not sharing data, and so I could go on, but I just wanted to bring this idea up in terms of court performance specifically. What type of data would help to, or what could be used to help promote improvements in courts themselves? So I'll stop there. Thank you.
Yes, I mean, I think like our judges are fabulous and our courts are amazing. Like there's many ways in which Canada has like the best judiciary in the world when it comes to the independence of it and like the high quality of the people we have. And I think we have a very high quality jurisprudence that comes out of it. And we have, you know, a court system which is independent enough to really move the law forward. Like the legalization of same-sex marriage is always something that, you know, I think of, right, as an opportunity that judges had to move the country way ahead long before elected branches would have done so. But I think when it comes to like, you know, garden variety civil disputes, judges are like overkill. Like I think, you know, a judge earns $430,000 a year, and they come with clerks, and they're very expensive. And to me, like a judge is like a luxury SUV that can go anywhere and do anything. But you know, if we only allowed luxury SUVs on the road, then most people would not be able to go anywhere because we can't afford it, right? And we need to think beyond, you know, just appointing more judges and look at ways to create abundant, just, prompt adjudication, which I think involves looking a bit more broadly.
Hi, my name is Matt Davidge. I'm with the Social Security Tribunal. I'm a bit of a data nerd, so I'm listening to what you guys were talking about this data desert, and it totally blows me away. We're lucky that we operate and we have a very robust case management system. We do a lot of surveys, and so we have almost an excess of data. And I was just wondering, when you're talking about the federal courts, is this an issue that, like, I assume they have some case management system. Is it that they don't have the tooling to extract the data? Because usually if you have a developer, you go do a SQL search into the database to pull some of the pieces out. Or is it that it's inconsistently tracked? Or is it that they have it, but it's very closely guarded to themselves and they don't want to release it? Like, what are your objectives? And then when you're getting your data, are you using some Python to do a scrape of the page, or are you having to rely on someone literally reading correspondence that goes back and forth between the party and submissions to try to glean that?
So I should say the federal court is a bit better. So I was more focused on the Ontario Superior Court of Justice, which handles the overwhelming majority of civil disputes in Ontario. The federal court's a bit better. They, for example, there's online searchable registry for the federal court where you can get documents on a case-by-case basis, and they report more data on an aggregate basis. With the Superior Court of Justice in Ontario, it's like they really don't want to cough up much of anything, and like the Civil Rules Review proved it, because that was approved at the highest level. That was the Attorney General and the Chief Justice of the court said, we're going to do this together, and yet they had no access to data. So that kind of proved, like, it's not just that they've got it and they won't let anyone have it, because if they had it, they would have used it in their own thing. So I don't know exactly what's going on. I think there's a technological shortcoming. It's still this Frank database, which I think is about 40 years old, and I think there was a failed effort to try to replace it. Anyway, I'd be speculating if I went beyond that.
Hi, my name is Maris. Hi, Noel. I'm from University of Windsor. So your question made me think, and I'm not sure if I just understood it differently, but I thought maybe what you were asking, what got me thinking, is not so much using some form of AI or expert system to do the adjudication, but more to tell the user what to expect. So you put your situation in however that works, and it might suggest that, your chances aren't good. Or, yeah, it might happen, but you will expect that it will take 6 months to get from here to here in this sort of situation, and another 18 months to get there. And that could be a very interesting way to think about things. I think it could go badly if it terrifies people and scares them away, but it also could make some people who need to be scared away. Honestly, it would almost be more like a quantum service on steroids, which I believe is something what Blue Jay Legal does. Is that kind of more what you were getting at? Yeah. Like more of an expectation management kind of tool than an adjudicative function?
Yeah, exactly. So, if I may.
Yes, of course.
I was just thinking about how, I go to these websites, like if there's a privacy issue, I can see how decisions have been made historically, and I'm doing my own little calculation about which factors are relevant to the situation I'm researching. Same with residential tenancy. I've done the same thing in my capacity as a landlord, for example. But it seems to me there's enough commonality of certain factors, like is hardship relevant? Is, certain things relevant? And I know it wouldn't be perfect, but it could give people an idea whether they have a legitimate case or not.
And the shape of what might be to come. Yeah, that's more what I was thinking, Rain. Yeah, thank you.
Now that I understand your question more clearly, well, what I can say is that our tribunal is considering AI in other ways. So, for example, we're looking at installing a chatbot, an AI chatbot on our website, so that prospective parties can come to our website and say, these are my circumstances. Can you tell me if I have a chance? And it will draw on the existing library, the content on our website. And we're pretty proud of our website. There's a lot of content there already. So we're hoping that that tool might be useful to those types of users. But this is early stages. This is really just at the discussion stage right now. So maybe I can turn the question around to you. Is this a feature that your clients would be interested in? And if so, who would actually use it? Keeping in mind that a lot of the users at our tribunal do come from vulnerable communities. They're self-represented. They have digital access issues, they have literacy issues, and other barriers. So would an AI chatbot, as fancy as it is, be of practical use? The other part of my answer that I want to give was that there was a session this morning on AI, and a gentleman from BC had created an AI tool called Beagle Plus, Canadian designed, with content specific to areas of law within British Columbia. Unfortunately, it's a fantastic tool by the looks of it, and it can respond to questions like, this is my legal problem. What are the steps ahead? What are my chances? And it spits out some really accurate answers, apparently. We would love to be part of the content of that AI. So that's something that maybe I could reach out to them and have a discussion about.
I'd say yes, but not the way you phrased it. In order for it to be a useful tool, it has to be able to do what in library land we call a reference interview. People don't know what they need or what they want. They know what they think they want. So unless it can push back and say, why do you want that? What are you hoping to achieve from that? What is your end goal? And make people think about what it is they're after, I don't think it will be very useful. A decent librarian and a decent tool gives you what you want. A good one gives you what you need by interrogating the experience.
Hi, Connor Shields with the Social Security Tribunal. Just a quick response to the AI conversation. Anecdotally, through my work as a registry assistant, things like that, you do see a lot of people who are intimidated by government in general, intimidated by these processes, exhausted, overwhelmed. I wonder if that kind of population, especially an aging population or a vulnerable population, would have more faith and trust in a chatbot than calling somebody, like a navigator. The idea of supplanting the navigator service as a personalized touch point of someone who knows the system, can explain to you what evidence may be relevant. I'm not sure most of the people I know who interact with Glenn surveys would trade that, but I'll just put that aside. Like Matt, I was kind of spooked by this data desert thing. It's almost a cliche to say that justice delayed is justice denied. How can anyone really defend not being accountable to time? Maybe I'll just leave it like that.
One thing they will say, and there's some truth in this, is that while justice delayed can be justice denied, it's also sometimes true that justice hurried is justice buried. So this was kind of an eye-opener for me with personal injury, talking to a lot of personal injury lawyers on both sides who will say that injuries may not crystallize, right? So if someone has suffered an injury from an accident, within the first 3 months, it'll be almost impossible to say what that person will be experiencing in 20 years. Just the way the human body heals, that to some extent, delay responds to the physiological reality that we won't know for a while how this person's life will end up, and therefore what amount of money would be necessary to make them whole. And then, of course, settlement also is the wrong answer in some cases, right? So in big public interest cases like Halpern that rewrite the law of marriage, settlement is inappropriate, and there has to be time for evidence to be gathered. So I didn't get a chance to get to it, but I have this definition and theory of timely justice, which tries to take account of the fact that it's not like calling 911. If you call 911, really you want the ambulance there now, and any delay is worse than no delay. Justice isn't quite like that. Justice, there is a sense of that doing substantive and procedural justice inherently takes some time, and perhaps that's a good thing in some cases. So there's some complexity there. Great, so I see an ominous timer here, 5, 4, 3, 2, 1. So I guess that means we're about done, but thanks very much for being part of this. And, yeah.